Testing the YouTube stream. Testing, testing. 1, 2, 3. Testing. This is a test of the Seventh Circuit Court of Appeals. Testing.
the United States Court of Appeals in and for the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as this court is now sitting. God save the United States and this honorable court.
Good morning, everyone. And before we start, Mr. Olson, if you would permit me a point of court privilege, and that is to welcome our newest member on behalf of the entire court, all my colleagues. I would like to extend a warm welcome to our newest colleague, Judge Nancy Maldonado, who is sitting with the court for the first time today. Welcome, Judge Maldonado.
Thank you. Thank you.
All right, Mr. Olson, you may proceed.
May it please the court, I'm Jeff Olson. I'm here representing John Sabo. 23 years ago, this court said that if through deliberate indifference, the requirements of state law, correctional officials kept him in prison too long, his Eighth Amendment rights were violated, even if the additional time was not very long. That was in Campbell versus Peters. All the cases that have been decided since then have taken that as a black letter statement that prison employees have a duty not to be deliberately indifferent when they learn of a serious risk of somebody being unlawfully kept in custody beyond the end of their sentence. Now, the panel majority decision is sound. Let's take a tour of a few of the objections raised by the state and the dissenting opinion. We concede that there's no duty to screen everybody. We put the word duty in our complaint in a couple of places to preserve our ability to bring a state law negligence claim, but there's no constitutional duty of deliberate indifference to get it right on the first time screening. If you get it wrong, that's at most negligence.
So you agree, Mr. Olson, that at the first screening, when they were reviewing the probationary terms and they were using the wrong chart to do it, that they did not have a constitutional duty at that point?
Correct, we do.
And it's your argument that the constitutional duty kicked in once they learned that the chart they had been using was not accurate.
Yes, because
What is the basis of the Eighth Amendment constitutional duty at that point? Where are you getting that from?
because they had, at that point, they were on notice that there was this group of prisoners at serious risk of constitutional injury to it being kept in custody for an over a long period of time.
How big does that group have to be before it's a duty? 1, 10, 1,000, 1,500?
One is big enough, but the fact that it's more than one doesn't relieve the actors of that duty. If one person, an ignorant or unreliable prisoner, complains that they're being held too long, that triggers very clearly a duty not to be deliberately indifferent.
The constitutional harm here, though, is an excessive probationary term, not being held too long, correct? And I know we have said in our case law that probation is a term of confinement, but that's the constitutional harm here, correct?
That, well, the constitutional protection is to be not kept in custody beyond the lawful limit.
But the harm here is the probationary term, because when they reviewed your clients and all the other inmates' judgments, it's not his term of custody that was excessive. It was the probationary term, correct?
Probation is a form of custody, though. It was the probationary term that was unlawful, but
So
probation.
you agree that that's what the constitutional harm here is, the excessive probationary term?
Yes. It's like the distinction between the initial screening and what their duty was when they learned of their error is like prison doctors. They may not have a duty to perform any medical screening when inmates enter their prisons. And if they do them gratuitously, and botch a few, that's not going to add up to deliberate indifference, negligence at the most. But if they learn that a defined group of inmates is at a significant risk of serious illness, they have the very modest constitutional obligation not to be deliberately indifferent.
How helpful is the line of medical cases to your argument here? Because the law is crystal clear that the Eighth Amendment imposes an affirmative duty at the prisons to provide the basic needs of inmates, which includes medical care. So how helpful, this is a different situation. How helpful is that line of cases to your argument?
I think when you get to the point of knowledge of a serious risk, it's really helpful because at that point, the obligations are exactly the same. The constitutional duty to provide some basic level of medical care, I don't know where that gets enforced, but I know where medical cases come from, and that comes from prisoners, either in groups or individually, who are learned to be at serious risk of serious medical condition. And then the prison health authorities or doctors do nothing or are otherwise deliberately indifferent.
As
That's-
basic as it is to receive medical care, isn't it equally as basic not to be kept in custody longer than one sentence?
It is. It is a basic aspect of Eighth Amendment jurisprudence now.
Mr. Olson, if I could ask you a question about the causation issue that has been raised. You cite Wisconsin statute that talks about the fact that if a term is incorrectly calculated by the judge, then it's commuted without further proceedings. Does that mean that in this situation, for example, I understand that as alleged, the two defendants corrected, when they do correct a sentence, they then send it to the judge who issued the sentence as a courtesy. What does that mean in terms of what further action did the judge have to take, if any, in order for that corrected sentence to take effect?
In 2004 and 2005, when this case arose, no judicial action was required because Hicks and Haley would correct that judgment of conviction, and they'd send the corrected judgment to the probation agent, who would in turn send a copy to the judge as a courtesy. The judge might or might not want to correct the court record, but the operant document that controlled the fate of the offender was the judgment of conviction as corrected by Hicks and Haley. And they felt they had the authority to do that pursuant to the statute that you cite.
So it's your position that under Wisconsin law, the judge did not have to take any further action in order for that sentence to be corrected?
That's what we believe at that time. But the more important thing is what happened to the offenders. And maybe you want to make some argument that the judge should have done something when he got that corrected judgment to rectify the court record, but it didn't affect what happened to the offender. The offender got let off probation or let out of custody based on Hicks and Haley's corrected judgment of conviction. There's some suggestion that there's no duty to be other than deliberately indifferent unless you know the specific identity of the person at serious risk of constitutional injury. The majority opinion recognized that objection and cited case law where the court has held that there is a duty to not be deliberately indifferent, even if it's a group of inmates who are at serious risk.
Counsel, could you explain to me why it violates the Constitution of the United States for state administrative officials to carry out a state court's judgment as it was written?
It's, if they had a
That's what
duty,
happened here, right? Your complaint is that administrative officials didn't change the judgment. I'm trying to go in two steps. Is there a constitutional right to have administrative officials depart from the language of a judgment?
maybe not, but there's a
Maybe not. All
constitution.
right. Second question. If state law says that administrative officials may depart from a judgment, does the Constitution of the United States require state officials to implement state law accurately?
And act in the teeth of the judgment?
Yes.
But no, but they have to do something.
Why
If
do
all-
they have to do something?
Because they have an obligation not to be deliberately indifferent.
Which decision of the Supreme Court provides your strongest support for the proposition that state officials must depart from the terms of a judgment?
I'm not saying they must depart.
No, I'm asking a concrete question about authority. What case do you want me to look at as your strongest case in the Supreme Court for the proposition that state officials must depart from the terms of a state court judgment?
I can't cite any cases in the penological
And
context.
I think that's because there are none.
That may
But if
be-
you knew of some, I would really love to see them.
There are in the warrant context where a police officer gets a warrant signed by a judge and he realizes the warrant is clearly unlawful. He's liable if he executes that warrant. But we don't need to go that far because all Hicks and Haley had to do was something. And if the something they had chosen to do
Now,
was to write this.
Let me put it this way. Suppose a state official deliberately violates a state law, goes out of his way to violate a state law. Does that violate the Constitution of the United States?
Not always,
Pardon?
not always.
Does it ever?
If it works simultaneously, a violation of a constitutionally
Well,
protected
All
right.
right. If there is an underlying constitutional right independent of the state law, that takes us back to my first question. Does the Constitution of the United States require state officials to depart from the terms of judgments?
Well, I think sometimes it does by analogy to the warrant cases, but that's not necessary here because all Hicks and Haley had to do was something. They were departing from judgments all the time with their little correcting pens, but they didn't have to do that. They could have done what they changed their practice to doing
Is
later
there
on.
Right, I'm asking a concrete question about decisions of the Supreme Court. And you're telling me what in your ideal world ought to happen. I might agree with you completely about what ought to happen in the ideal world, but we need to know what the established law is. That's what's worrying me.
Well, the closest I can come to Supreme Court is the warrant cases, but as I was trying to say, we don't need Hicks and Haley to depart from the judgment. We just need them to do something reasonable. And if that something reasonable is to write to the judge, as they would do today, and say, we found an unlawful aspect of this sentence and we think you should correct it, that would satisfy their constitutional obligation without interfering with or requiring them to act in the teeth of any state court judgment. The state tries to distinguish cases where this court has found a duty not to be deliberately indifferent, where there's a group of affected people rather than just an individual at serious risk of constitutional injury in a couple of ways. One is they say that in this case, there was some basic right. There was some basic constitutional duty. Well, we've covered that. We think there was a constitutional duty not to be deliberately indifferent when you learn of the injury. We don't think that distinguishes this case from other cases where prison officials have learned of the prospect or serious risk of injury to groups of inmates. The state said that second, in the cases where this court has found a duty not to be deliberately indifferent, when the risk is aimed at a group rather than an individual, the state didn't have to know, the officials at issue didn't have to know the identity of the affected eventual victim in order to take some meaningful corrective action.
What, Mr. Olson, what cases do you, when you say cases where we've talked about risk vis-a-vis groups, or what cases do you have in mind?
I think it's Brown versus Buns. It's cited and discussed in the majority panel opinion. Well, in this case, Hicks and Haley didn't have to know the identity of any of the prisoners with an unlawfully long term of probation to take some reasonable action either. And they didn't have to re-review or reinvestigate thousands of judgments of conviction of all the inmates who'd come in over a period of many months. They could have just done something reasonable. They were the only ones who knew about this problem. For all we know.
Like what?
What?
What, like what?
Yeah.
Give me an example of what they could have done, and then you'd say, oh, no constitutional violation, even if your client, even if they didn't catch Mr. Sabo's error. They
Here's
did
what,
something, it was enough to satisfy you under the Eighth Amendment, even though Mr. Sabo's term of imprisonment and probation was illegally extended.
here's what they could have done. They could have contacted corrections legal counsel. Together, they could have formulated a plan. And I don't know the ins and outs of the Department of Corrections well enough to know everything that they could have done at that point, but they certainly could have sent out a circular to all the probation agents. All these people on probation have probation agents. And if you just add one item to the probation agent's checklist for every visit with a probationer that says, look and see whether this person was put on probation for a class.
That sounds like a review of every single person that went into the prison over those several years. In some form. It sounds like they have to go back and check every single one of those in some form, whether it's them that does it or somebody else.
But it wouldn't involve ever getting out a file for the purpose of reviewing it. It would involve just reviewing one aspect of a probationer's file when the probationer came before the agent for something else. It might add 10 or 15 seconds to the probationer's encounter with the probationee, with the offender, and it would have been a light burden on everybody involved. Very practicable thing.
Well, what about people that maybe were re-imprisoned because they committed a violation while on probation, and so they didn't have a probation officer? In other words, someone's term of probation is illegally extended, they get out, they re-offend, they're rearrested, they're back in jail. They don't have a probation officer. Who checks those?
I don't know, but if I were the Department of Corrections legal counsel, I could come up with somebody.
Well, isn't the point that factual development, if we're talking about what a reasonable action would be and, you know, what was confronting Hicks and Haley in these particular circumstances, so that we can see if it's at all analogous to prior cases like Haywood, Haygood, or Sample, or so Campbell, so forth, so on. Isn't the point that factual development would help answer those questions about what particular circumstances confronted Hicks and Haley and what they could have done or could not have done, what would have been reasonable, what would have been too onerous? We simply don't know at this pleading stage.
If the court decides that whether or not they had a duty not to be deliberately indifferent depends on whether there was something that they could have done that would have had a probability of success without too much burden on the system. And only if the court decides that, I think, does the case need to be developed further factually to explore those things about the Department of Corrections and what they might have done that I don't now know. But I don't think it depends on that. I think that they had an obligation to do something reasonable. And even if it only was going to wind up helping less than 100% of the affected probationers, they still had the obligation.
How
If we
should it-
move to the qualified immunity question, and particularly going back to Jeff Scudder's question in regards to the Brown case that you raised, I would be interested to know what would have put these record keepers on notice that of the rule that if you are aware of a risk of unlawful probation terms, you are required under the Constitution to go back and make corrections to that sentence. So I know we talked a little bit about Brown, but can you just lay out for me the best cases that you have of that reasonable notice?
Sample versus Dirks out of the Third Circuit and Judge Griesbach's opinion that followed it very precisely that we quoted in our brief.
Now, in the sample case, we know that the official was put on notice that there was a term of imprisonment of a particular individual. And so, and if we lay that against the facts of this case, what would have put those record keepers on notice?
Cases like Brown, but you have to put that together with the cases that find group risks in other contexts. I don't know that I can cite a case of group risk of unlawful incarceration. But it's very clear that the fact that it's a group doesn't extinguish the duty. And if you're there in the epicenter of responsibility, you have a duty. Qualified immunity.
Mr. Olson, if you can't cite a case of group risk of unlawful incarceration, how does that allow the law to be clearly established for purposes of qualified immunity?
Because the principles are absolutely clear and there's no gray area.
Well, that
Yeah.
makes me a little concerned when we look at the instruction from the District of Columbia case from the Supreme Court.
Westby.
The excuse me, I didn't catch that.
The District of Columbia versus Westby case, that where we're instructed that it can't be merely suggested by precedent.
Mr. Olson, let me ask the question a different way. So I think the challenge that you have on qualified immunity is convincing us that this is not an extension of existing law. In other words, the best case I think you have in your pocket is FIGS. But FIGS is notice, is it not? There's knowledge as to, the plaintiff, an individual person. And so here, when you make the point about Brown and you invoke the failure to protect cases and you talk about medical care, there's absolutely no question that medical care has to be provided in prison to a group. No doubt about that. But when you get at the nub of what Judge Brennan is asking you here about an extended sentence, a probationary sentence here, it's very hard to see how this is not an extension of existing law. And the difficulty that you have is if it's an extension, you run into that language in the U.S. Supreme Court's qualified immunity cases that say at prong 2 that it has to be, the legal principle has to be clearly established beyond debate.
I don't think this is an extension because I think it's an application of black letter principles that coalesce to make this particular action unlawful beyond debate.
Okay, and so would you say FIGS makes the outcome here just preordained? There is absolutely no question about it.
Not by itself, but with that and the other cases from the circuit, yes.
I heard you citing Campbell. We knew as early as 2001 that keeping someone in custody for an unlawful period of time is an Eighth Amendment violation. That's Campbell in 2001. White, 2001, parole is a form of custody. Then you've got these cases from the 80s and 90s, and you also cited Brown, where prison officials are liable for deliberate indifference so long as they know of a substantial risk of harm to a group of prisoners. So I hear you to be saying you've got Campbell, White, you've got these group cases saying there's liability if you know of risk of harm to a group. That all is established before 2005.
That's exactly right. And with your permission, I'd like to save the rest of my time for rebuttal.
It's fine, thank you. Ms. Keycaver.
Good morning, and may it please the court. Wisconsin Assistant Attorney General Carla Keycaver, appearing on behalf of defendant appellees, including Sherry Hicks and Deborah Haley. The question before this court is whether administrative employees in the Department of Corrections can be personally liable in federal court for a state sentencing court error. Sabo alleges that Hicks and Haley subjected him to cruel and unusual punishment when they failed to discover a sentencing court error. But they had no constitutional duty to do that. Without a constitutional duty, they could not be deliberately indifferent to Sabo, and his Eighth Amendment claim fails.
Is it fair to say that his allegation is that they failed to discover the error? Seems to me, reading the complaint, his allegation is that they did discover the error. Someone gave them a chart. We don't know who. Again, these are allegations in a complaint. And that once they were given the chart and they did indeed realize they had been making this mistake, that they did nothing reasonable to mitigate, not prevent, mitigate the substantial risk of harm to a known Eighth Amendment violation. And the examples he gives is they could have called in his brief, they could have called the Department of Corrections, legal counsel. They could have sent a general letter to all probation officers saying, hey, if you've got a probationer with a Class H felony, refer them to review for us. Or they could have written a letter to the judge. All judges. So is it fair to characterize the complaint the way that you just did?
I think it is, Your Honor. There are two problems with Mr. Sabo's constitutional claim under the Eighth Amendment. And the first and probably most basic and important is that Hicks and Haley had no constitutional duty to discover and prevent sentencing court errors in the first place. Every case that addresses deliberate indifference to prolonged incarceration involved prison officials' failure to properly execute a sentence. So a different group of people at the Department of Corrections does this kind of work where they're calculating the release date or they're assessing whether good time applies. That was their job. This is a different thing that Hicks and Haley did. Their job under state law was to review judgments of conviction for errors. And that was a job responsibility, but there's no case that establishes a constitutional duty for them to do that.
So, Ms. Keycaver, I just want to make sure I understand your position. So if Mr. Sabo's attorney, right, sent a letter to Hicks and Haley saying that my client, his term of probation is calculated incorrectly, would you look into this? And they decided not to. Is it your position that even in that factual scenario, that Hicks and Haley had no duty to do anything in response to that letter?
I would agree that they have no constitutional duty to do that because they have no constitutional duty to discover sentencing court errors and prevent them only under state law. And under the Department of Corrections policy, did they have a duty because of their jobs to review judgments of conviction? So even if he had come forward, they did not have a constitutional duty to do that. Now, we know from the pleadings that they did do something and they would do something because Janelle Nearing, when she did learn of Mr.
Well,
Sabo's.
I guess I'm just trying to understand the way you're trying to distinguish the prior case law that we have where a prison official is notified by the inmate or inmate representative about a particular error and the officer did nothing. And so what you're saying is that the distinction is that in those cases, the official's responsibility was to execute the sentence. But here, there's no duty because Hicks and Haley's job was not to execute, but merely to make sure the sentence was correct.
That's right, Your Honor. The difference between those cases, so there's two different points. There's no constitutional duty for Hicks and Haley to discover sentencing court errors by reviewing the judgments of conviction. That was a Department of Corrections policy to review judgments. And then second, for those cases where Department of Corrections officials were actually looking at different judgments of conviction and calculating release dates, their duty arises only when someone comes forward. And that's because the failure to protect cases have not been extended in this context. So in order for Mr. Sabo to be successful, this court would have to extend those cases to this context. In the failure to protect cases, a finding.
So let's take it, for example, a prison guard, right?
A prison,
And
I'm sorry.
A prison guard.
Yes.
And let's say let's take it in the context of a medical need, okay? And so a prison guard has no state obligation to make sure that someone's medical needs are taken care of. And let's say that the state guard comes across an inmate who is suffering from some serious medical need, right? In that case, the state guard would still have some obligation to do something under the Constitution. Will you agree to that?
Absolutely, because.
And so it's not so much dependent upon, I suppose, what their particular duties are under the state law, as Judge Easterbrook noted, but kind of constitutionally, whether they're aware that a constitutional right is being infringed and whether they're deliberately indifferent to it, right?
Well, what I would say in that context, we're talking about a custodial relationship where the officials, including the guards in the prison, have a constitutional duty to provide adequate medical care, adequate safety, food, shelter. And that arises by virtue of the fact that there's this custodial relationship. Here, there's no similar constitutional duty for Hicks and Haley or officials at the Department of Corrections to review judgments of conviction for errors.
Well, I guess, let's, as Judge Jackson-Fumio was saying, it's not necessarily review and perhaps just semantic, but to correct, right? Is there a duty for them to correct known errors? You would say no. Is that correct?
For Hicks and Haley
Yes.
to correct, no, there's no duty for them to do that.
And even if Sabo was in prison, incarcerated, and then Sabo's lawyer said, hey, Hicks and Haley, this term of imprisonment is incorrect. You calculated this incorrectly. Can you take a look? Your argument is that even under that scenario, they would have no duty to do anything.
No, that's not my argument. My argument is in that scenario, when they're actually doing the calculating. So I think what's confusing is that there are two different groups of people that do these jobs at the Department of Corrections. There's Hicks and Haley, who were in the Division of Community Corrections Records Office. And their only job was to look at judgments of conviction and put them next to 97309 and see whether those judgments of conviction were correct in their estimation. They're non-lawyers, but they gave it a look. Then there's another group of people who are in the Department of Corrections Division of Adult Institutions. They then look at the different judgments of conviction and calculate release dates and apply good time credit. So they're doing something affirmative where they're not just reviewing a judgment that a court issued, they're actually doing a calculation.
But the judgments they're looking at are the ones that Hicks and Haley reviewed, right?
Not necessarily, because Hicks and Haley might only be reviewing a probation term, which I think is what Mr. Sabo's judgment was. It was only a probation term. It didn't include a period of incarceration. I mean, he violated, so then he was put in jail on a hold, but it didn't include a period of incarceration.
Everything you're explaining certainly couldn't come to us from the pleadings and then in a motion to dismiss. I struggle then with wondering whether we need, again, factual development so the state can explain who has this job, et cetera, et cetera, et cetera. But it was not, how do you see that as Mr. Sabo's job to do that in the four corners of his complaint rather than meet our very often articulated requirement to plead facts sufficient to raise a plausible claim for relief?
And I would agree with you. What I just articulated is not in the pleading, but it's on the department's website. The court could take judicial notice of that. It just provides some helpful background for this case, but I don't think it's necessary for the district court's decision dismissing the Eighth Amendment claim against Hicks and Haley. If you take every allegation in the complaint as true, Sabo still cannot state an Eighth Amendment claim against Hicks and Haley. So every allegation in the complaint, for example, looking at the number of errors, I think this is maybe a good time to talk about the number of errors. He alleges that there were 5 to 6 errors every day that Hicks and Haley on average that they looked at. And this was just an estimate on their part in the pleadings. This is paragraph 416 of the complaint. And that works out to about 1,000 to 1,500 errors a year of any type. It's not just the type of error that we're talking about relating to felony probation terms. It's an error of any kind. And what we don't have in the pleadings is the denominator in that scenario, but we know it was at least a year of work for these individuals. So we can assume that it was a lot of judgments of conviction that they looked at. And we know from subsequent discovery that it was around 40,000 per year. So that's the class of people we're talking about. And I agree, that's not in the pleadings, but I think the court can assume based on the pleadings that it was a large group of people that we're talking about. It's not the 1,000 to 1,500 people. That's just an estimate of any type of error.
But
So
if you want us to take, I don't know if you're going that from there, we must assume then that it's onerous or unreasonable. Would that be drawing an inference in the state's favor at this pleading stage?
well, I don't think the court even needs to get to that. Just as a practical matter, it's helpful to know.
If we were to assume that, would that be drawing an inference in the state's favor at this stage as opposed to Mr. Szabo's favor?
I don't think that the fact that they reviewed judgments, and we're talking about a year plus period of time of reviewing judgments, I don't think that goes in any either.
No,
either
I'm saying the
side's favor.
inference you're leading to from there, that it might be onerous or unreasonable to take some action to address that.
I don't think the court even needs to decide whether it's onerous or unreasonable, because Mr. Szabo's claim now is not that they were supposed to go back and re-review. It's only that they were supposed to take some reasonable action. But if they had no constitutional duty to review judgments of conviction in the first place, we don't even have to decide what the next step was. They could not have been deliberately indifferent to Szabo if they did not have a constitutional duty. So I want to go back and look at the failure to protect cases. I think in order for Mr. Szabo to be successful, he has to extend those cases in this context. And those cases are Brown v. Buds and Farmer v. Brennan. And in those cases, as I discussed, they're different because there was a constitutional duty because of the custodial relationship to provide safety to these prisoners while in custody. And here, as we've been discussing, there's no similar constitutional duty to review judgments of conviction. But those cases are different for another reason. And in those cases, the official's action or inaction contributed to the risk. So that what they did happened before the actual harm happened. And here, Szabo does not allege that Hicks and Haley did anything to contribute to the risk or to make matters worse. And in fact, the Department of Corrections would not have doesn't have to have this policy at all. They wouldn't have to review judgments at all. They've just decided as a policy matter that they would do that. And I also want to discuss 97309 sub 2M, which is the provision that we've discussed a little bit about. At one point, the Department of Corrections thought it had authority to unilaterally commute sentences. It has since determined that it doesn't. We know that from the pleadings because when Szabo came forward, Janelle Nearing did not cross off the judgment. She suggested that his attorney go to the sentencing court, and then she also wrote a letter to the sentencing court. And
But
then
what was the process back in 2004 and 2005?
the process in 2004 and 2005 is as alleged in the complaint.
So they could have unilaterally changed it, and that's.
Well,
all.
they did, whether that was appropriate or not. They now think that is not appropriate, and they no longer do that. So moving on to qualified immunity. In 2005, when Szabo alleges that Hicks and Haley violated his constitutional rights, and any time thereafter, no case clearly establishes that prison record keepers who learn about a type of sentencing court error have a constitutional duty to discover an error as to a particular person and prevent the prolonged probation. The cases addressing prolonged incarceration are not sufficiently particularized to this case for at least 3 reasons. First, the existing cases all involve an error in prison officials' failure to execute the sentence. So again, it's their calculation that was the error. Here, Hicks and Haley were just reviewing judgments, and no case clearly establishes a constitutional duty to review judgments of conviction. And second, those existing cases all involve situations where the defendants were aware of a particular person. Somebody came forward or they learned in some other way about a particular person, not some error possibly affecting a group of people, but a particular person. And here, even if this court wanted to extend the failure to protect cases to this context, that's never been done before. So that would not be clearly established law. And third, the case is addressing prolonged incarceration, not prolonged probation. And this court might decide that that difference doesn't matter here, but no case clearly establishes that prolonged probation is cruel and unusual punishment.
And indeed, as a result of his excessive probation, he did end up with prolonged incarceration because he ended up being arrested and kept in jail beyond the term that he was supposed to be free. So there was, it just so happens to be a confinement aspect to even Mr. Sabo's case. Would you agree?
That's right, because he violated his rules of probation. He was kept on a parole hold for some amount of time. So there was some incarceration. But no case has clearly established that prolonged probation, prolonged incarceration by virtue of being revoked, that clearly establishes a constitutional violation in this context. Ultimately, this case boils down to state officials doing their jobs. They might not have done them perfectly, but their actions did not rise to the level of an Eighth Amendment violation. For these reasons, we would ask that this court affirm the district court's decision dismissing the Eighth Amendment claim against Hicks and Haley.
Thank you. Mr. Olson.
This case is easier than it otherwise might be in a couple of key areas that go to the issue of qualified immunity. If qualified immunity is a good thing, it's there to keep public officials from having to act at their peril in gray areas of the law where they're close to the line. A couple of areas in this case where that's not the case. One is with respect to the question of duty. Were these people situated such that they had a duty to take some action when they gained this knowledge of serious risk of constitutional injury? The best formulation I can think of is Judge Griesbach's formulation in Watford versus Miller, where he says, if you're in a position where you're pretty sure if you don't do something about this serious risk of which you've gotten notice, nobody else is going to, you have a duty. It's right, as Judge Easterbrook observed in the Burks versus Ramish opinion, that public officials don't have a free-floating duty to set things right. But these people were in the very epicenter of duty. They were like the doctor who reads the positive tuberculosis test for the inmate. That doctor knows if he or she doesn't do something about that result to address that risk, probably nobody else in the system is going to do anything either. The second area where this case is easier than it otherwise might be is in the area of the nature of the response when you learn of a serious risk of constitutional injury. Your obligation as a public employee when you learn of that risk is to do something reasonable to address it. Now, you can imagine a lot of cases where public employees would be doing something and we'd be here arguing about whether it was reasonable or not. And the qualified immunity proponents would have a lot of grist for their mill because the line between what's reasonable and what's not when it comes to responding to a serious risk might be hard to draw in some cases, but it's not hard here because these folks did absolutely nothing. So we don't have to worry about whether they might have been confused about where the boundaries of reasonable action were. They did nothing. In their brief, the state says that plaintiff has to show that the unconstitutional action was the cause of injury. That's wrong. Very clear. It can be one of several causes. In Whitlock versus Brueggemann, this court in 2012 said there are often multiple proximate causes, and it does not matter that other acts are also proximate causes of the ultimate violation, or that some of those acts were taken by an actor who is absolutely immune, such as in this case, the sentencing judge. The state and the dissenting opinion thought that this case was controlled by parole, the P-E-R-R-A-U-L-T parole case. And in that case, there were allegations about Hicks and Haley, but those allegations eventually didn't have anything to do with what happened to parole, because he was not on probation. He was on extended supervision. How did those allegations get in his complaint? Well, he copied one of my old complaints from another case, and he was over-inclusive. In terms of qualified immunity, the state makes the point in its brief that Hankins versus Lowell, the case where this court applied the deliberate indifference standard to a parole agent and held that parole is a form of custody, that's why that standard applies, wasn't decided until after the events at issue. So they say that fact supports their qualified immunity argument that it wasn't clearly established that parole, probation, and extended supervision were forms of custody back in 2004, 2005. Well, it was, because the cases that Hankins versus Lowe cited for that proposition all came from before the events at issue in this case, including Jones versus Cunningham, the US Supreme Court case, where they said parole is a form of custody, and explained why, because it's so onerous. This court had said on multiple occasions before 2004 that probation is a form of custody as well. In Drollinger versus Milligan, 552 and second 1220, and Fawcett versus Bablich, 962 F second 617. Thank you very much.
Thank you. Our thanks to both counsel. The case is taken under advisement and the court will be in recess.